Welcome to the second of the Week 6 podcast. In this podcast, we look at two additional grounds of review that fall under the umbrella of an improper exercise of power. The first is an exercise of power at the behest of another, and the second is the inflexible application of a rule or policy. The exercise of a personal discretionary power at the behest of another is a ground of review under Section 5(2)(e) of the ADJR Act, and there is an equivalent in Section 23(e) of the Judicial Review Act of Queensland. Sometimes this ground is referred to as acting under dictation. This is not allowed, as if the legislature has vested particular decision-making authority in a particular person, they have to be the one who makes the decision. There can't be someone whispering in the decision-maker's ear and telling them what to do, but they can still get advice and reports, etc. Importantly, the decision-maker can't be overborne by someone else. They have to turn their mind to the question at hand and not just follow someone else's dictation. So we therefore need to ask ourselves, was the decision-maker overborne, or did they exercise their discretion properly? This may mean that they still reach a similar decision to what their advisor has said, but they haven't substituted that person's view as their own. This is quite difficult for ministers who want a particular outcome, and they may have helped to secure the appointment of a high-level government official in order to achieve that outcome. The public servant who is receiving these whisperings, if not instructions, from the minister, has to be very careful that they are in fact making their own decision, which is not unduly influenced by political considerations and concerns for job security. The decision maker must follow the statutory criteria. What about if the statute recognises a valid role for the minister in the decision-making process? For example, the legislation might say that the decision must be made by the Director General, but the Minister has a veto power. In other instances, the statute may specify that the Minister can make a recommendation. In the case of bread manufacturers of New South Wales and Evans, a Prices Commission had the authority to set the maximum price of bread. The Minister had advised that the price of bread should not be increased, and the Prices Commission increased the price of bread by a marginal amount, which was similar yet slightly different to the Minister's advice. The bread makers said the Prices Commission had set the price too low to make bread making profitable. This case was brought very soon after a national wages dispute, and it was highly politicised. The relevant statute recognised that the minister did have a role to play in the decision and could veto the decision, but the ultimate decision did have to be made by the Prices Commission. The question was the decision invalid because the Prices Commission asked the advice of the minister before making its decision? The High Court said that if a role for the minister is specified in the legislation, it's highly unlikely that the courts will find that the decision maker was overborne by the minister. This is especially the case where the decision involves high-level government policy. Here, decisions about bread prices in the context of wages and cost of living might be seen as a high-level government policy. It makes sense that if the minister had a veto power here, the Commission would seek advice from the minister before making the decision and without having committed a legal error in doing so. So where the subject matter involves high-level government policy, it is more difficult to establish that a decision-maker has been overborne by the minister. This was confirmed in the cases of R and Anderson, ex parte IPEC Air, and Ansett Transport Industries and the Commonwealth. In other words, it is appropriate to have regard to government policy if the decision-making power concerns high-level political issues. What about decisions involving high-level government policy when a decision maker is operating under a chain of command? This issue was considered in the High Court case of CPCF and the Minister for Immigration and Border Protection. To provide some context for this case, you might like to pause the podcast and watch the first 2.5 minutes of the short clip from the ABC 7:30 report that is the link for which is provided on the slide. As the news clip shows, the facts of this case were that in June 2014, a vessel embarked from India bound for Australia. Those on board the vessel, 157 Sri Lankans of Tamil ethnicity, intended to claim asylum in Australia. The vessel never reached Australia though. It was detained by an Australian customs vessel in the contiguous zone, that is, the zone adjacent to Australia's territorial sea. When the Indian vessel became unseaworthy, the passengers were taken onto the Australian vessel. At the direction of the Commonwealth Government, acting on a decision of the National Security Committee of Cabinet, the maritime officers on board the Australian vessel detained the asylum seekers for almost 1 month while they attempted to negotiate a deal with India to take them back. When these negotiations were unsuccessful, the passengers were taken to immigration detention on the Cocos Islands. The plaintiff in CPCF was one of the Sri Lankan asylum seekers. He commenced proceedings against the Commonwealth, claiming that his detention was unlawful and seeking damages for wrongful imprisonment. A series of questions were referred to the full court of the High Court, and one of these was whether the maritime officer acted under dictation from the National Security Committee, and this is our focus here. The argument that the maritime officer had acted under dictation from the National Security Committee failed because, in short, the legislation contemplated that the powers would be exercised in a chain of command. This meant that the directions of the National Security Council were binding on the more junior maritime officers. All judges agreed on this point. The court focused on the nature of the powers and the circumstances in which they were to be exercised. The maritime officers were relatively low-ranking officers, and the significant powers entrusted to them would often require the exercise of substantial discretion. Here, the exercise of statutory power raised questions about foreign relations and were therefore a matter appropriate for decision at the highest levels of government by ministers of the executive government who are responsible to government. And they were the words of Chief Justice French. The plaintiff's claim ultimately failed, with a majority of the court holding that the detention was lawful under Section 72(4) of the Migration Act. This case reinforces that if the exercise of the statutory power raises high-level political questions, this time about foreign relations under a chain of command, it will be difficult to make out that the decision maker has acted at the behest of another. Our next ground of review pertains to the inflexible application of a rule or policy which is codified in Section 5(2)(f) of the ADJR Act and Section 23(f) of the Judicial Review Act. It is similar to the previous ground, but this time the undue influence on the decision maker is coming from a policy rather than from a person. Basically, this ground of review means that if legislation grants decision makers a discretion, policy guidance can't unduly limit this discretion. It can't be too rigid. A rule or policy here means a non-statutory or extra-legal rule, guideline, policy, precedent, etc. So, for example, it might include departmental manuals or guides for decision makers. It can also include policies formulated at higher levels of executive government, which may be evident from ministerial announcements or directions. The rule or policy can't just be applied blindly and rigidly without considering the merits of the application. So when you're reading through an administrative law problem question, these are two things you need to look out for: departmental policies and executive policies, and you need to check whether they're in line with the statutory provisions. If not, and they have restricted the decision maker's discretion, there may be a breach of this ground of review. A benefit of these types of policies and guidelines is that they increase the consistency of government decision making. However, the policy itself still has to be lawful, and how it's being applied also has to be lawful. Lawful means valid in relation to the statute. That is, the policy must be consistent with the subject matter, scope, and purpose of the Act. It is the responsibility of whoever is writing the policy to make sure that it is consistent with the Act. A key case here is Green and Daniels, which was a High Court case about unemployment payments. The facts of this case are that Karen Green registered for unemployment benefits in November, the day before she completed the fourth form of high school, which is the equivalent of our Year 10. She was told she could not receive unemployment benefits until February. There was a departmental policy that, as a general rule, school leavers will not be entitled to satisfy the conditions of eligibility until the end of the school vacation. This policy was aimed at stopping students claiming benefits in the break and then deciding, oh, actually, I will return to school after all. Karen Green brought an application for judicial review in the High Court, seeking a declaration that she was entitled to the benefits and an order for payment of arrears. Karen Green satisfied the objective requirements of eligibility under the Act. She had been applying for jobs and appeared to have a consistent intention not to return to school. The third requirement was that the Director General of Social Security had to be satisfied of certain things. The Director General had not formed any satisfaction of these matters because he had applied the policy that school leavers shouldn't receive payments until the end of the school vacation and not taken into account the merits of Karen Green's application. The issue considered by the High Court was whether the department's approach was okay. Had the department just formulated a guide as to how to exercise their powers, or had the department effectively substituted the criteria enacted by Parliament with their own criteria for what should qualify an applicant for an unemployment benefit? The High Court found that the policy itself was not lawful as it was inconsistent with the Act. The time frame that was set was arbitrary and had nothing to do with the statute. Some people in Karen Green's position might be deceiving the department and not truly be unemployed. Others, however, might be. The policy forecloses the Director General's mind to the latter possibility and will lead him to be wrong in some cases. The court said that the quite understandable desire to prevent what is seen as an abuse of the Act by dishonest school leavers cannot be made the occasion for disregarding the statutory criteria of eligibility in favour of a requirement which finds no place in the legislation. The court found that the Director General should have considered Karen Green's application and turned his mind to the criteria listed in the Act, rather than just blindly applying the policy. Therefore, two questions to ask in an administrative law problem question are, firstly, is the policy, guideline or manual itself lawful? And we look at the subject matter, scope and purpose of the Act to determine this. And secondly, was the policy blindly or inflexibly applied without regard to the merits of the case? Note that in this case, the court would not remake the decision due to the legality merits distinction under the separation of powers. As the statute had given the task of deciding whether Miss Green satisfied the requirements for benefits to the Director General, this decision was remitted back to the Director General to remake the decision according to law. This is one of those relatively rare administrative law cases where a successful judicial review action did not work out very well for the applicant. Here, the Director General again decided that Karen Green was not entitled to receive benefits from the 20th of December 1976, which is what she had argued. A number of other school leaders who were in a similar position complained to the Ombudsman, who first tried to get the Director General to change his policy, and then complained to the Prime Minister, who made act of grace payments to 3 individuals. Karen Green, however, received nothing. Then, to make matters worse, the government's response to this judicial decision challenging the operation of the policy was to amend the legislation to entrench the policy. What often happens in judicial review matters is that successful applicants for judicial review are also successful when their case is reconsidered. And often there are changes in departmental practices and policies to bring them into alignment with the law. Here, however, the law was changed to bring it into alignment with the departmental practices and policy. The new law required a 6-week waiting period after leaving full-time study before a school leaver could become eligible for government payments. Another important case is that of IPEC Air. This case looks at the difficulties which arise where the subject matter of the decision involves high-level government policy, which, as we've discussed, can be difficult terrain for judicial review. This case, and also the Ansett Transport Industries case, which we mentioned previously, both involve the 2 airlines policy. Back in the day before the airline systems were fully privatised, there were 2 government-subsidised airlines. IPEC Air wanted to operate a freight airline system, and although it met the relevant statutory criteria, it was refused because it had the possibility to expand and interfere with the 2 airline policy. The Minister told the Director General to refuse the application as it was potentially a political issue and there were no limits on what consideration should guide the Director General's discretion. IPEC Air claimed this was an inflexible application of the government policy. The High Court was split on this issue. The key distinction between Justices Kiddo and Menzies in the minority and Justices Taylor, Owen and Windayer in the majority is the characterisation of the role government policy played in the Director General's decision. For the majority, the government's 2 airline policy was a relevant consideration which the Director General ought to and did take into account. So for the majority, there was no legal error. For the minority, the Director General crossed the line He did not just take government policy into account, but decided he had no choice but to obey it. The decision was dictated and in truth made by the government rather than the Director General. So for the minority, there was a legal error. Note that here, as with other cases we've looked at, the court was more reluctant to apply conventional judicial review, where it is a matter of high-level government policy with a minister involved, and again, this is due to the separation of powers. It is important to note that there is no problem with administrative decision makers being guided by policy. It's just that policy can't be applied rigidly without regard for individual circumstances. For example, rules made under the Migration Act allow the Immigration Minister to cap the number of humanitarian visas that are granted each year. In Plaintiff M64 of 2015 and the Minister for Immigration and Border Protection, the High Court considered whether a delegate of the Minister had properly considered an application for a special humanitarian visa. There are a number of criteria prescribed in the regulations which the Minister had to consider in deciding whether or not there were compelling reasons to grant the visa. In addition, the Minister published a list of processing priorities for special humanitarian visas. In other words, there was a government policy for prioritising people whose sponsors had arrived in Australia unlawfully. The applicant's application, made on the basis of close family in Australia, fell into the lowest priority category. In the decision letter rejecting the applicant's visa request, the Minister's delegate referred to the government's processing priorities. One of the arguments before the High Court was that the delegate's reference to the processing priorities guidelines involved an inflexible application of policy. The court did not see a problem with reference to the processing priorities. The court noted that the high degree of subjectivity in deciding whether there were compelling reasons to grant a visa highlighted the importance of these guidelines. The guidelines, the court said, avoid individual predilection and inconsistency in making choices between a large number of generally qualified candidates. Whilst following policy was considered desirable in this case, the Minister or his delegate should not go so far as to say that the policy will be applied rigidly without regard for the merits of individual cases, as this would be a reviewable error. So this brings us to the end of our materials for podcast 2. Before we finish, let's run through a few revision questions to test our understanding of these concepts. Under Section 5(2)(e) of the ADJR Act and Section 23 of the Judicial Review Act, where the dictation or influence is coming from a government minister, which of the following is not a relevant factor? A, is the minister from the relevant department? B, does the minister have veto power in the legislation? C, is there a legislative provision relating to consulting with the minister? Or D, is the subject matter a critical matter of national importance? What do you think? The answer is A. Whether the minister is from the relevant department is not relevant to the test for acting under dictation. Higher level government decisions are often multifactorial and interconnected, involving more than one government department. If the influence is coming from a minister from another department, this ground of review can still be made out. B is incorrect because this is relevant to acting under dictation, as more leeway will be given to the influence of a minister who has a veto power, as this is what Parliament intended. And we saw this in the case of bread manufacturers and Evans. However, you must still consider whether the decision maker's discretion has been properly exercised or abdicated. C is also incorrect. Although not as strong as a veto power, this is also relevant to consider as Parliament obviously intended some role for the minister to play. Again, however, you must consider whether the decision maker's discretion has been exercised properly and individually, or whether they have been overborne. D is also incorrect. This is relevant to think about as high-level policy may be given a determinative weight, and the courts may be reluctant to interfere if a matter is of national importance and high-level government policy. We saw this in the case of CPCF and also in the cases of IPEC Air and ANSET. Which one of the following statements is least correct with respect to Section 52F of the ADJR Act and Section 23F of the Judicial Review Act? A. For a policy to be lawful, it must not be inconsistent with the subject matter, scope and purpose of the legislation. B. For a policy to be lawfully applied, consideration must be given to the merits of a case. C. A policy cannot be blindly or inflexibly applied. Or D. A policy is a relevant consideration that must be applied. Which of these is least correct? The answer is D. For A, B and C, we know they are correct from Green and Daniels. Option D is the least correct, although there is possibly overlap with the relevant consideration ground of review, particularly where there is high-level government policy, as we saw in IPEC Air. Nonetheless, primary regard must still be given to the statutory criteria and the merits of the case. So this concludes this podcast. A major focus of the next podcast will be on the unreasonableness ground of review.